Chapter 31, Malicious Mischief. Section 563. Definition. As regards the definition of malicious mischief, at common law, the authorities are in hopeless conflict. As generally understood at present, the offence may be defined as the willful, physical injury to, or destruction of, the property of another, either personal or real, from ill will toward the owner or possessor thereof, or, as held by some courts, from wantonness. Section 564. The offence at common law. According to Blackstone, malicious mischief, at the English common law, was only a trespass. He states, however, that it is now by a multitude of statutes made penal in the highest degree. A few decisions in this country are in accord with Blackstone's view that malicious mischief was not indictable at common law, but by the great weight of authority this view is not sustained. Section 565. Statutory enactments. As previously stated, numerous statutes have been passed in England declaring malicious mischief, in specific cases, a penal offence. Many similar statutes have been enacted in this country. Section 566. Malice against the owner. Many decisions hold that the element of malice, which is an essential of malicious mischief, must be against the owner or possessor of the thing injured. Mr. Freeman says that the malice called for in a charge of malicious mischief, is malice against the owner or possessor of the property, and not toward the property itself or toward any other person, is no doubt the established rule relative to this crime, as it existed at common law at least, and as it has been expounded and determined by a long and uniform line of judicial decisions. It has been held, however, that malice against the owner or possessor is not essential. Section 567. Origin of the rule requiring malice against the owner. The origin of the discordant rule requiring malice against the owner or possessor of the property was the general reluctance on the part of the courts to recognize this offense as a crime at all, preferring to treat it merely as a civil trespass. In consequence of this reluctance they required that a vindictive and malevolent motive actuated by malice toward the owner of the property, and intended to annoy and injure him, be shown. Section 568. Mode of proving malice. It has been held that positive proof of actual malice against the owner or possessor of the property is essential. This view, however, is not in accord with the great weight of authority. It may be inferred from declarations, prior acts, or the nature of the injury. Moreover, personal ill will against the owner is not essential. The element of malice may be inferred from wanton and reckless acts showing a mind disposed to mischief. And in an Ohio case, where the accused was indicted for unlawfully, willfully and maliciously injuring a horse, the court holds, after an exhaustive examination of the English cases, that where the incentive for the act is general malevolence, cruelty or depravity, it is sufficient. Section 569. Acts within the scope of this offence. The following acts, when done maliciously, have been held by the courts to constitute malicious mischief: to kill a cow, or other domestic animal, to break up a boat, to deface tombs or monuments, to shave a horse's tail, to set fire to barrels of turpentine, to break and tear down telephone wires, to injure a harness, to injure fruit and ornamental trees, to cut the guy posts of a lighting plant, to place obstructions on railway tracks, and to discharge a gun with intent to annoy and injure a sick person who is near. Section 570. Justification of the act. The plea of justification may constitute a good defense. For example, where the accused is indicted for maliciously killing an animal, he is entitled to introduce evidence to show that his purpose in doing the act was to protect his crop, and it is error for the court to refuse to permit him to show that the animal was habitually inclined to commit mischief, and that it was restrained with difficulty from doing so. Again, the accused may justify his act by showing that it was done under legal advice, and that he entertained the belief that he was authorized to do it under a claim of right. The fact, however, that the holder of the property was wrongfully in possession of the same is no defense. Section 571. Injury to the property. However malicious the act may be, it is not criminal unless the property is materially injured or destroyed. And where the property is an animal, it has been held that the act must amount to a killing. This view, however, is not the better one. Section 572. The indictment. The nature and character of the injury should be alleged with sufficient certainty to identify the transaction and accurately describe it in detail. The malice of the accused should be alleged and the name of the owner of the property stated. Where the property belongs to an unincorporated company, the names of the members should be stated. But it is not necessary to allege the value of the property unless it is material as to the penalty.